Good evening. My name is Hugh Wilkins. I'm a lawyer at Eco-Justice Canada. Eco-Justice is a charity which focuses on strengthening environmental law in Canada. Our lawyers take on cases in the courts which will set, we hope, precedents which will strengthen environmental law, and we make recommendations for law reform to again strengthen the laws in Canada on the environment. Actually, just so you know, we used to be called CR Legal Defense Fund. About 18 months ago, we changed the name for several reasons, so there's sometimes a bit of confusion about that. I plan to make two brief points this evening. The first is that in many respects, we have a greater need for anti-SLAPP legislation in Canada than in U.S. jurisdictions. However, so far, we don't have any. The second point is that momentum is building, and I think what Norman was just saying is a good example of that. Momentum is building in Ontario and elsewhere in Canada for anti-SLAPP legislation. And we already have the models used in the U.S. and in the Canadian provinces to guide us in building an effective anti-SLAPP regime. The key now is to get on with it and to develop some legislation. We do not presently have any anti-SLAPP legislation in force in this country. But SLAPPs are a significant problem in Canada, which is evidenced by the cases which David was speaking about and others earlier today. The problem is only getting worse. We do have the constitutional right to freedom of expression in Canada. However, unlike the U.S. First Amendment, our charter rights have not been extended to civil suits between private parties. In Dolphin Delivery, which was one of the first charter cases addressed by the Supreme Court of Canada, the court firmly found that private disputes do not attract charter attention. But are SLAPP suits, which are based on public comments made to public decision makers in the public interest, truly private in nature? SLAPPs, by definition, threaten important public rights that are critical to the functioning of our democratic system. While the source of the harm may be private, the harm itself directly affects the democratic process and is unquestionably public. The state is clearly implicated by virtue of its direct interest in open and unfettered public participation in government decision-making processes. Perhaps it is time to revisit this aspect of Canadian jurisprudence. However, as it is today, without the constitutional or case law protection against SLAPPs, which is present in the U.S., we have a greater need in Canada for anti-SLAPP statutory reform. As our provincial government has been slow off the mark in taking action to protect citizen participation and the integrity of our environmental laws, we in Ontario have the awkward advantage of being able to survey the variety of types of anti-SLAPP legislation that has already been enacted elsewhere, most notably in the U.S. and in Australia, as Romney pointed out. There's plenty of anti-SLAPP legislation in place, particularly in the U.S., and we can look at those laws and how they've been judicially interpreted and applied in order to get a better idea of what works and what does not. There are signs of life indicating that such legislation may arrive soon in Canada, for example, in Quebec. Already, several provinces, including Nova Scotia, New Brunswick, and currently Ontario, have had private members' bills introduced in their legislatures, showing that momentum is growing regarding the need to address SLAPPs. But in each of these cases, with respect to the private members' bills, they were opposition bills brought before a majority parliament. So thus, none have succeeded with private member bills into becoming law. In the last number of weeks and months, Environmental Defence and CELA and Eco-Justice have been discussing what the needs are for anti-SLAPP legislation in Ontario. And we've come up with 5 broad principles, which are set out in a handout, which I think people have received tonight. These broad principles, we believe, should form the basis for any piece of anti-SLAPP legislation that is passed. They actually are in line with what Norman was stating before with his 6 points. The first one is that legislation must protect all forms of public participation aimed at procuring government action. Second point that these pieces of legislation should have is it must provide broad immunity from civil liability for persons engaging in public participation. It should provide for early review and an expeditious process for summarily determining the matter. Fourth, it should reverse the onus and summary dismissal proceedings so that the initiator of the lawsuit must show that the action has merit. And fifth, The law should provide strong and effective disincentives, financial or otherwise, to dissuade potential SLAPP plaintiffs from initiating a meritless claim. The bills that have been put forward in the Canadian provincial legislatures so far have varied in their abilities to meet these requirements. As discussed by Norman again, the Quebec Bill 9 is very broad in scope and includes a reverse onus provision, which is important, but it does not, in my respectful submission, have a strong definition of public participation, and it does not provide absolute immunity from civil liability for SLAPP targets. In New Brunswick, Bill 102 was introduced by the NDP in 1997. It established a right to participate in the process of government and to petition government, a right to petition government, and it also protected these rights from SLAPP suits. In the law, it said that a contravention of the Act would be a ground for summary judgment, and it placed the onus on the respondent to show that the Act did not apply. It also allowed for substantial indemnity costs and for punitive damages to be awarded against SLAPP plaintiffs if they were not successful. This was a private member's bill, and it was not adopted, so it's not law today in New Brunswick. BC enacted an anti-SLAPP law in April 2001 when the NDP government was in power there. It offered a strong definition of public participation. It permitted a summary process for dismissing SLAPP suits and provided for punitive damages. It did not include a reverse onus provision, and it did not include broad immunity from liability either. Unfortunately, it was repealed shortly after Gordon Campbell and the Liberals took office in 2001. I believe the new government had concerns that, among other things, the law did not provide judges with sufficient guidance for distinguishing claims that had merit and those that did not, among other reasons. Other provinces which have put forward anti-SLAPP legislation include Nova Scotia, which introduced another private member's bill in 2001. It was modeled on the BC law almost identically. It, again, was a private member's bill, and it did not get adopted by the government. Notably, also in Ontario, we presently have a private member's bill before the legislature for anti-SLAPP. It was brought by Andrea Horwath last December, and it is also identical to the BC and the Nova Scotia bill. So the NDP sort of have this model bill which they've been putting forward in the different provinces. As David noted earlier, it's identical. Well, he didn't note this, but it has a provision in it which allows for the staying of proceedings while a SLAPP suit is being determined. So it's, the Ontario Act is different from the BC and the Nova Scotia bills in that one respect, which is an important respect. Also of note in Ontario are the upcoming amendments to Rule 20 on summary judgment in the Ontario Rules of Civil Procedure. In his Civil Justice Reform Project report, which was released in November 2007, former Court of Appeal Justice Coulter Osborne made important recommendations on changes to Rule 20. These recommendations were to facilitate the granting of summary judgment. Many of these recommendations have been accepted by the government and have been made into amendments to the rules which will enter into force in January 2010. Although the summary judgment test of no genuine issue for trial will remain, Osborne's recommendations include the conferring onto a judge on summary judgment motions the authority to weigh evidence, evaluate credibility, and draw inferences, which is something new. Also, the new rule will allow for the holding of mini trials with, in appropriate circumstances, oral evidence to be allowed to be produced in these many trials in order to dispose of matters in a summary fashion. These changes to the rules are important. However, they do not attack the roots of the SLAPP problem, in that they still require SLAPP victims to be subjected to the risks, costs, and uncertainty of being thrust into legal proceedings, and they provide few disincentives, such as significant cost consequences, to dissuade SLAPP plaintiffs from commencing these actions. It is the preventing of the filing of SLAPP suits which ought to be the main aim of anti-SLAPP legislation. Simple changes to the rules will not suffice. We believe that with greater public awareness and discourse on the issue of SLAPPs, political momentum will continue and effective legislation to stop these meritless claims will be developed in Ontario. As we have seen, the need is there and the models are available to guide us. Now is the time for action to be taken and for anti-SLAPP legislation to be enacted in Ontario. Thank you very much.